All right, Abusuami Chow na misan so emu akwaba emra e channel so that's why be media YouTube so be so wa say obe subscribe e dey amai bobo notification bonus for more podcast updates. Nene me demo ebo awura mu akọ parliament yes na asem asi ewo parliament. Enya asem keto ne ade Haruna Idrisu yes watumi ashoke MPs parliament na de ensem na do tudwa abra speaker of parliament ema no kwan so betumi adi nkomo yenko na yetie ne nsem a ode atudwa ebi a meka me hu ensem lika yi pese ya ayeko na yetie na yeche ya adwen comment section ha so aye be media gichabusia bomodi aso be subscribe e dia my notification bell for podcast updates na be channel so se be media gichabusia ye ni atem ya adwen na yeche woni aye tene de ye hu social media so ma yenko na yentie
Yes, Honorable Minister for Education.
Mr. Speaker, thank you very much for the opportunity to speak in support of the learned Attorney General, Dr. Ayeni, on the adoption of the report of the Committee on Constitutional, Legal and Judiciary on the Tribunals Bill 2026. Mr. Speaker, and in doing so, to draw attention just to three fundamental matters. Is the Attorney General upholding a constitutional imperative in the pursuit of this bill? He is, Mr. Speaker. And Mr. Speaker, may I reference Article 142 and then probably attempt to respond to the Honorable Buama. Mr. Speaker, Article 142 provides, and I quote, 1. There shall be established in each region of Ghana, each regional tribunal as the Chief Justice may determine. Constitutional. So the Attorney General is only enforcing a constitutional imperative. And I believe, Mr. Speaker, in doing so, let me refer you to paragraph 5.1, page 5 of the committee's report, and probably just conclude on that note, Mr. Speaker. Mr. Speaker, the Minister is reported to have indicated the backlog of cases of traditional court continuing to increase at approximately 3,360 cases. What this House must bother about this is, will this contribute to the administration of justice? That is what we should be concerned about. Will the establishment of the regional tribunal enhance access to and the delivery of justice in Ghana? It will. Mr. Speaker, to assure our colleagues opposite that we have long left the dark days behind us. We have long left the dark days behind us and the administration where there were excesses. So be assured that not under President Mahama and not under Minister Ayeni will you witness any excesses in disrespect to fundamental freedoms and rights. When that happens, this House will stand up and rise up to ensure that our democracy is never ever compromised, because those remains the fundamental blocks of our democracy. So, Mr. Speaker, let me assure our colleagues that those dark days are over. And then finally, there will be no excesses. This Attorney General will not proceed on any trial without any regard to Article 19 of the Constitution. So you don't drive those rights from a minister. He would proceed guided by the Constitution. And then, Mr. Speaker, to assure our colleagues, let's not take for granted Ghana's progress, Mr. Speaker, including Speaker's contribution. We now have a democracy, and we have a country where the rule of law is manifest in all its facets. The rule of law in Ghana, whether equality of the law, natural justice, is manifested. So be assured that the Attorney General and government is only seeking to enhance the delivery of justice. Then, Mr. Speaker, I'm minded by your quote long ago. I'm sure around 2015 was when you used the quote here. Ghana's judicial system, slow and tortuous, was attributed to Speaker Bagbin those days when he was in his role here. How do we improve the long, slow, tortuous delivery of justice in Ghana? And then finally, we must have a judiciary that is fearless and independent. If that is what you are advocating, we would support you. Mr. Speaker, we've seen the U.S. Supreme Court recently in the citizenship debate tell President Trump that no, your attempt to review an 1868 legislation which gives citizenship rights, the court will not stand with you. What we need is a strong, independent, and fearless judiciary that must deliver timely justice. In Ghana, the problem is they say justice delayed is justice what? Denied. There are cases in the court that have run 20, 30 years. Why? Mr. Speaker, with this, I support a motion.
Yes, I heard you correct somebody about your name. But there's one name you didn't add.
Mr. Speaker, I didn't hear the last thing you said. You said you heard me correct my name.
Yes.
Yes.
But I said there's one you didn't add to the name.
Oh. Which one?
But you go on.
Mr. Speaker, I'm not saying sorry. It's the name. Mrs. Is that it?
Oh, I see.
Thank you very much, Mr. Speaker. Mr. Speaker, I heard the submission of my good friend and the Attorney General. And I also heard your submission that we should be open-minded. Mr. Speaker, when you look at the report on page 6, paragraph 5.2, with your permission, I read, it says, the committee observed that the history of tribunals in Ghana remains a sensitive subject for many citizens. It evokes painful memories of fear, intimidation, and human rights abuses associated with the operation of tribunals during previous political regimes. So it is not just us, but a majority of the citizens. And like my colleague said, I think we should go out there, the AG and team should go out there and engage as much as possible to help reduce or take away this painful memories or this sensitive situation that citizens think the coming of these tribunals will create. Mr. Speaker, secondly, I believe that Ghana has spent 3 decades strengthening our court systems. And as a result of that, there's been specialization in the area of the criminal courts, the commercial courts, the land courts, and the human rights courts, as well as even Parliament establishing the alternative dispute resolution mechanism that is really helping. And so I think that with the creation of a tribunal of this nature, it will be more of duplication rather than improving institutions that we already have. And so we should look at it again. And then, Mr. Speaker, introducing lay persons as voting members of the tribunal is also a concern to me. Because the minister said that this will be in the area of crime. And with these things, Mr. Speaker, you will need consistency, you need predictability and legal certainty. So that if you introduce lay people into such situations, you ask yourself, will they be looking at the facts? Or they'll be looking at their concerns in society, how people view them in society, and what they think is the law or what they think is the remedy for a crime committed, and not the facts that they are faced with. So, Mr. Speaker, it is indeed a concern to me and many other people. And, Mr. Speaker, I also feel that in the bill, I saw somewhere that they said that the participation of persons selected will be based principally on high moral character and proven integrity. Mr. Speaker, who determines that? Who determines someone of high moral character and proven integrity? And how is it defined? How is it going to be defined, Mr. Speaker? And so what I will say is that no matter how desirable this characteristic is, that is not going to help solve matters of criminal nature. And so, Mr. Speaker, if we want people of high moral standing, I think for the courts have managed to take look at the facts and in terms of criminal issues rather than sentiments. And by introducing lay people into these things, we risk going back to situations where we found ourselves previously with these tribunals. with these tribunals. So, Mr. Speaker, we would want one, per your advice, that more haste, less speed. The Honorable Attorney General should go back, look at the bill again, address the concerns that we are raising here, and if possible, strengthen the already existing courts so that, one, we do not promote duplication, and then two, we look at the facts and determine things based on legal certainty, predictability, and not sentiments per se, because I have a strong feeling that per what I learned and read about with the previous tribunal, it was more on sentiments and feelings rather than real facts that they are faced with. And so we want to avoid these things. And I believe we have come a long way as Ghanaians as we practice our democracy. And I believe that if we do not take care in managing this situation, it can have a negative impact on our democracy. So, Mr. Speaker, with these few words, I'm not a lawyer, but with these few words, I'm grateful for the opportunity. Thank you very much.
Yes, I'm happy you are now studying law. And so you will soon be a lawyer.
Thank you very much, Mr. Speaker. Mr. Speaker, I rise to support the adoption of the motion. And Mr. Speaker, may I humbly say that from the definition of a tribunal is a specialized adjudicatory body, often a board of committee officially authorized to resolve specific types of disputes. Mr. Speaker, listening to my brother who was speaking, his submissions were shrouded in political debates. Believe.
Honorable member, the definition you just read, is it in
yes,
the bill?
Mr. Speaker, from Google. From Google, a tribunal.
From Google, okay.
Yes, from tribunal. Mr. Speaker, it is clear, it is very clear that the honorable member has not read the bill. He hasn't abreast himself with the nitty-gritties in the bill. That's his argument. Mr. Speaker, it is, as was said earlier, it is a constitutional provision which is being carried out. And as has been said, in fact, I must put on record, and all of us know, that this tribunal is not going to deal with civil matters. It's going to help in adjudication in criminal matters. My brother was mentioning district court, circuit court, high court, etc. And the Court of Appeal and the Supreme Court. The Court of Appeal and the Supreme Court, except the Supreme Court sometimes having original jurisdiction in constitutional matters, the Court of Appeal and the Supreme Court do not have original jurisdictions. And the courts, as have been mentioned, the district court, the circuit court, and the high court, they have their criminal aspect, which is this tribunal going to complement, going to help. And Mr. Speaker, if you look at the bill as has been presented, it has specific matters which the tribunals, both the district and the regional tribunals, are going to deal with. Tribunals have been in the minds of persons. It was in the minds of persons during a particular time. We are now in a constitutional era. And looking at the bill, as was stated by the Venerable Attorney General, all mechanisms which are in the Constitution to protect rights of persons, all mechanisms to ensure that people who appear before these courts and the tribunals are given fair trial, are passed through procedures, rightful legal procedures, are all in the bill. So it is something that we should embrace to help in expeditious trial of criminal matters. Mr. Speaker, if somebody is charged with a criminal offense, sometimes it takes years for that person or that matter to be dealt with. Sometimes 2 years, sometimes 3 years. And if somebody has a criminal charge around that person's neck, it becomes an albatross which doesn't make the person think right, because that person would have to always respond to the calls from the courts. So with this, if you are able to have these tribunals that help in the districts and in the regions, it will help expedite trials. It will help that for people to be tried, whether the person is guilty or not guilty, that person is going to have a expeditious trial to be able to have his fate determined. And Mr. Speaker, I believe that if we accept this and pass this bill, it will help all of us. It will help in the criminal jurisprudence. It will help in criminal justice delivery for the betterment of all of us. So I humbly pray and add my voice to the call for all of us to accept this and to make it go through for the betterment of all of us. Thank you very much, Mr. Speaker.
Please, minority from bench, I don't have your list yet. The list of those who want to contribute. Yes, please.
I'm grateful, Right Honorable Speaker, for the opportunity to contribute to this important report as presented to us by the Joint Committee on Constitutional and Legal and the Judiciary with regards to the Tribunal Bills 2026. Mr. Speaker, ordinarily, the conversation around the establishment of a tribunal operationalization wouldn't have been much a cause because it is constitutionally provided. As rightly indicated in Article 142, in fact, when you start from Article 126, the Constitution provides that the judiciary shall consist of the superior courts of judicature, that is the Supreme Court, Court of Appeal, High Court, and regional tribunals, and such lower courts or tribunals as Parliament may by law establish. So the framers of the Constitution created that opportunity for a tribunal to be created. If you go to Article 146, the Constitution provides for the creation of the regional tribunals. And the Constitution clearly indicates the modalities in which the regional tribunals are supposed to operate. I've read the report from the committee, and I'm not that convinced as to the rationale behind currently bringing this bill for operationalization. I believe that a more compelling argument in terms of why we think there's a need to bring about the regional tribunal and the district tribunals will suffice. Mr. Speaker, why do I say so? If you take the report, if you get to page 5 of the report, which is the rationale for the bill, it says that the Attorney General, second paragraph, 5.1, the Attorney General and Minister for Justice explained that the establishment of the tribunal has become necessary in order to address the backlog of cases in the traditional court and to promote access to justice. He further indicated that the backlog of cases in the traditional courts continue to increase by approximately 3,360 cases annually. So if one of the main reasons for bringing about the tribunals is to deal with backlog, then you ask yourself, with the current establishment of the traditional courts, what is the cause of the delays or the backlogs being created? Is it a matter of not having enough justices? Is it a matter of us not having sufficient courts? Is it a matter of the digitalization of the court process that is not effective? So we should be able to address the entirety of the challenges that the traditional court faces, based upon which then you think there is a reasonable cause for us to establish a tribunal. So for me, the first rationale by the Attorney General in terms of clearing the backlog doesn't suffice because there's no much basis in explaining why there is a backlog, why the traditional courts do not have the capacity to deal with the criminal cases as enshrined, for which reason he's bringing this bill. Mr. Speaker, the second reason why I have a challenge with the Attorney General bringing this issue up is even about the qualification of the empanelment. Mr. Speaker, I take you to page 8, 5.4, minimum qualification of members. The report indicates that some members were of the view that the bill should prescribe minimum qualifications to ensure the panel members possess, at the very least, basic literacy skills to understand the records of proceedings, documentary evidence, and other communication necessary for effective discharge of their functions. Other members, however, were of the opinion that the panel system was intended to encourage broad public participation, regardless of educational background. They argued that prescribing minimum qualification in the bill could unnecessarily disqualify or discourage otherwise capable and committed individuals. They further noted that the bill empowers the Chief Justice, who is best placed to determine suitability of prospective panel. Accordingly, they considered it unnecessary to prescribe minimum qualifications in the bill. How on earth will you come to this house establishing a tribunal that is supposed to determine matters, and you say that there's no prescription for minimum qualification for members? I find that very untenable, because if you take the judicial system, the structure as espoused in the creation of courts, there's always a minimum qualification for someone to sit. Even at the district court, the regional tribunal is of the equivalence of a high court. You are creating a district tribunal that may be of equivalence to district tribunal. The district court is headed by a lawyer of a minimum qualification. And then you are telling us that you want to create a tribunal both at the regional level and at the district level. You are empowering the Chief Justice to put people on there without minimum qualification. That for me is problematic. So what do we, and this is about criminal justice. The criminal threshold is for people to be made. People are supposed to be charged on beyond reasonable grounds. And so when you don't have that minimum qualification, on what basis are we creating this? Mr. Speaker, to continue with my objection to what is before us, unless they take it back, is about the expeditious trial. One of the rationales that the Attorney General brought to the fore in this report, and that takes you to day-to-day 5.5, that day-to-day hearing of related cases, minor related cases by the tribunal. The AG is submitting to us that the tribunal, one of the focal areas the tribunal is supposed to make determination is to the area of Galamsey fight. And I'm asking the Attorney General, when it came to issues of the fight against Galamsey, we purged it at the High Court for the courts to make determination. Now, if you are bringing in a tribunal and say that there will be expeditious trial day to day, what stops the traditional court from sitting day by day? Because it is a matter of case management. So if you have a matter that you want expeditious trial, it is for the Chief Justice to make that determination and ensure that the court fast-track the processes and we create the enabling environment for the cases to be tried expeditiously. So in all intents and purposes, I have a big issue. I'm not against the establishment of a tribunal, because that is already provided in our constitution. But what is presented before us in terms of this report, I find it insufficient, I find it inadequate, I find it unconvincing, and I want the entire house, both sides of the aisle. I always say that when we bring legislations to this house, it is not majority against minority. It is about the practices that will best serve the interests of this country. And if we look at some of these matters, we should look at it from bipartisan angles. And I'm of the view that if members are to thoroughly look at the provisions or the reports before us, a lot more work has to be looked in. The Attorney General has to go back and properly consider some of the provisions that are here so that we can all in unison look at it. Now, the issue about stigmatization, which has been in this country a matter of concern, even before bringing about this bill, there should have been sensitization in the public domain. The Attorney General and the government should have sensitized the people of this country that this is our intention. These are the issues that we face in the court. It is for the well-being of the Ghanaian people. The issues of the past would have to be taken out because it is not for nothing that Ghanaians are worried. I am a lawyer. The AG is a lawyer. We all know the role of tribunals across, and the speaker mentioned it. So the mention of the tribunal, we understand. But my old lady in the village, people who have suffered adversely in the area of the tribunal system ought to be educated so that that stigmatization will end at some point. And I have never seen any advertisement or any promotion or education that seeks to speak to these issues coming up. And so, Mr. Speaker, I want to humbly submit that we refer this matter back to the AG. He should take it back, look at it in the entirety, and when some of these concerns are addressed, I'm sure we will come together as a house to look at the best interest of the bill in the interest of this country. I thank you so much, Mr. Speaker, for the opportunity.